So I did, as I indicated this morning, receive the defense's proffer regarding alternate perpetrators. That will be sealed per request, I'm assuming per stipulation. And I want some additional information. What I'd like is by the 23rd, if possible, for the defense to do two things. One, provide me with whatever actual evidence you have that supports those allegations, rather than just allegations. And two, provide for me how it is you believe that what you are offering is admissible. Because it seemed to me much of what you had put in there was fairly potentially fairly objectionable in terms of admissibility. So I would like to see that. And then I would have the state respond by the 6th, which is 2 weeks. And then I would propose a hearing on the 18th.
I show you how deep the rabbit hole goes.
Like you, be strong to hold the powers of the sun.
Listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I am your host, Pavarotti, and I'm here to discuss the Idaho 4 case. Now, in the opening, I played the portion in the recent hearing where the judge was discussing the outline of when things needed to be submitted as it related to the alternative perpetrator, the actual evidence, the response from the prosecution for it, and the hearing date, which would be June 18th. Now, the date that the judge actually gave the defense for giving the proof of the alternate perpetrator proffer is actually today. Now, I know we just got the motion to continue, and with that motion to continue, you would think specifically that it would put off all the proceedings that we've already had, scheduled by the judge as far as alternate perpetrator, but obviously until that motion is heard, nothing changes in this case. So that means today would have been the deadline for the defense to offer the alternative perpetrator proof. And I firmly believe that there was something that hit the case summary yesterday, and that was the defense complying with that proof. So the next step would be on the whatever date they said, it was 2 weeks from the 15th, so probably be the 29th. That the prosecution would need to respond to that, and then the hearing will be held on the 18th. So what I want to discuss in this video, first of all, let's take a look at that case summary so I can show you what I'm talking about. So on the case summary right here, it says amended notice of compliance dated 5/22. Okay, so I firmly believe that was the defense complying with the judge on entering their offer of proof. Now, we've got to understand this, and I know that for those of you that have been following me, I went in deep on a particular case, and it's called State V Meister. And the reason I went in deep on that case is because it is the case that is cited by the defense, the prosecution, and the judge as the ruling case in Idaho as it relates to alternative perpetrator evidence being submitted to a trial. And there are some caveats to that. What we're going to do is, and for those of you that remember, it's very, very strange that Meister was actually a case that was tried by Bill Thompson in Moscow back in 2001. The similarities between the Meister case and the Koberger case are very apparent. For example, one of the things they convicted Meister on was he had purchased a gun before that unaliving, Now, they didn't arrest Meister till 10 months after it. By the time they arrested him, he had already sold that gun to somebody. But because he had purchased a gun before that unaliving, even though they never located the weapon, they tried him in court like that was the unaliving weapon. Very similar to what you're seeing here in the Kohberger case with, they're saying he purchased a K-bar 8 months before the unaliving. They've never found the unaliving weapon, but they're trying to claim that the K-bar that he purchased was the unaliving weapon. Exact same thing. Some of the other things that got Meister convicted was they rounded up a bunch of people after the fact, people that I have dove in on that have extensive criminal histories, and they testified that, to hearsay that they heard Meister talking about committing the crime. And then they put Meister in a room down there at the Latah County Jail, I imagine, and didn't record anything and hammered him in there for hours upon hours and forced a confession out of him. And he later recanted that confession as being forced out of him, but they still tried him on all the facts. So what happened in the case? Well, they tried to submit alternative perpetrator evidence. The district judge did not allow it, and they sentenced him to 140 years in prison. And from all the things that I've looked at in that case and some of the things after that case that have happened recently, I don't believe that is a righteous case either. And I believe that guy Meister is sitting in prison right now, and he's not guilty as well. But that's another day, another story. They did appeal that conviction, and an appellate court ruled that the judge in the case should have admitted the alternative perpetrator evidence, and they granted him a new trial. Unfortunately, they granted him a new trial in the same court with the same people, and even with stronger evidence, they excluded more evidence and convicted him again. It's terrible. Once this case is over, I will absolutely do my best to expose everything in that case. But because of that case, and because the defense, the prosecution, and the judge cite Meister as the law of the land as it relates to alternative perpetrator evidence, we're going to have to dive in a little bit deeper into that case so we can clearly understand where they're getting these rules of evidence. So what the Kohberger defense team is up against with their proffer for the alternative perpetrator, and what the law actually states around this, and how do you apply the law. And that's where things get really complicated. And I'm going to show you in the end something that I've learned about our judicial system, that it's a red pill, blue pill moment. Be ready for it. If you don't want to take the red pill, you want to keep that blue pill, stop this video right now, because I'm going to show you some truth in here about our legal system. Let's jump right into case of Idaho versus Meister and get the particulars so we can discover what is necessary for the evidence of alternative perpetrator to be entered into the case in the Kohberger case.
State V Meister, 2009. Supreme Court of Idaho. This case arises from a 2001 shooting death of Tanya Hart in Moscow, Idaho. David Meister was charged with first-degree murder and conspiracy to commit murder. It was alleged that Meister shot Tanya in exchange for $1,000. A jury convicted Meister on both counts, and Meister appealed. The Court of Appeals remanded the case for further proceedings and resentencing. The state petitioned this court for review. This court accepted review on the following issues. 1. Whether this court's decision in State v. Larson, or IRE 403, is the controlling authority for the admissibility of alternate perpetrator evidence. 2. Whether IRE 804B. 3. Contains a corroboration requirement for the admission and confessions of an alternate perpetrator. And 3. Whether the district court violated Meister's right to due process, right of appeal, and Fifth Amendment rights by threatening a harsher sentence if Meister refused to admit guilt. Factual and procedural background. This case was a Moscow, Idaho case, and it was prosecuted by William Thompson Jr. Bill. On December 11th, 2001, Tanya Hart was shot twice in her home in Moscow, Idaho, which she shared with her boyfriend Jesse Lindemann. The shooter approached the front entrance of Tanya's trailer and then proceeded to the back entrance, point 1. When Tanya opened the back entrance of the trailer, she was shot twice, once in the chest and once in the face. The shooter then retreated behind the trailer, running through a snow-covered field and eventually exiting the field on a nearby road. A neighbor heard the gunshots and went to Tanya and Jesse's trailer. He then called 911 and proceeded unsuccessfully with resuscitation efforts. Tanya was pronounced dead at the scene. In August of 2002, the police interrogated David Meister in connection with Tanya's death, and Meister confessed that he shot Tanya in exchange for a $1,000 payment from Jesse Lindemann. Meister was charged with first-degree murder and conspiracy to commit murder. Charges were initially filed against Lindemann for conspiracy to commit murder, but those charges were later dismissed because the only evidence tying Lindemann to the crime was Meister's confession. At trial, Meister attempted to admit evidence that another individual, Lane Thomas, was responsible for Tanya's shooting. The district court refused any evidence which showed Thomas was an alternate perpetrator of the crime, including several confessions. A jury convicted Meister on both counts, and the district court sentenced him to a fixed term of life for the murder conviction and a unified sentence of life with 40 years fixed for conspiracy conviction. Analysis. The alternate perpetrator evidence that Meister attempted to admit at trial consists of Lane Thomas's confessions and evidence which tends to suggest that Lane Thomas was the actual perpetrator of the crime. Thomas's confessions and evidence which tend to implicate him in the shooting of Tanya are governed by two standards under Idaho law. This court must first determine the standard for admission of alternate perpetrator evidence. Although Thomas's confessions are included under the umbrella of alternate perpetrator evidence, the confessions also constitute hearsay. Therefore, the confessions must then be analyzed for admission pursuant to the hearsay rules. The state argues that all of the evidence in Meister's offer proof is inadmissible pursuant to various evidentiary rules. The state's motion in limine seeking exclusion of all alternate perpetrator evidence was granted. Therefore, Meister's counsel was never afforded the opportunity to lay the foundation properly for any of the evidence. This court will refrain from acting as a fact finder and makes no determination as to whether the evidence is admissible. In the present case, Meister was not afforded the opportunity to provide a full and complete defense for crimes of which he was accused. The district court applied the wrong standard for the admission of the alternate perpetrator evidence. Therefore, this court vacates Meister's conviction and remands this case for a new trial. IRE 403 is a controlling authority for the admissibility of alternate perpetrator evidence. The rules of evidence embody the balancing test which safeguards a defendant's constitutional right to present a defense along with protection of the state's interest in the integrity of the criminal trial process. For instance, IRE 412 employs a two-part test to evaluate whether a defendant's Sixth Amendment right to a defense is violated in light of IRE 412. First, the trial court must consider whether the evidence proffered is relevant. If it is not relevant, the defendant has no constitutional right to present it. If the evidence is relevant, the trial court must ask whether other legitimate interests outweigh the defendant's interest in presenting the evidence. The rules of evidence properly protect the trial court's discretion to limit relevant evidence if the probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. IRE 403. If the defendant proffers evidence which merely tends to mislead the jury that another person committed the crime, or the evidence is not relevant because it does not tend to make the defendant involved more probable or less probable, then it is within the trial court's discretion to find the evidence inadmissible. Mere inferences that another person could have committed the crime will most likely not be relevant, and if relevant will still be subject to the limitation provisions of IRE 403. A defendant has no right to present irrelevant evidence, and even if evidence is relevant, it may be excluded in certain cases.
In the present case, the court's ruling does not address whether the evidence is relevant and admissible pursuant to IRE 401, 402 or 403. Instead, the court ruled that any evidence relating to Lane Thomas as an alternate perpetrator was inadmissible pursuant to this court's decision. This finding was in error. The court refused the request of the defense to call Lane Thomas as a witness and any witness which may impeach Lane Thomas's testimony, or to present any evidence which would tend to show that a person other than Meister committed the crime. By excluding all this evidence from being presented in any context throughout the course of trial, the district court prevented Meister from presenting potentially relevant facts that may have developed throughout the course of the trial. Meister should be afforded the opportunity to present his complete and full defense, which includes the presentation of all relevant evidence in the context of trial pursuant to any limitations of the Idaho Rules of Evidence. The district court erred by applying the wrong standard for admissibility of alternate perpetrator evidence, and therefore, abused. The offer of proof and the record contain two reports from people who heard Lane Thomas confess to the Tanya Hart shooting. One is a police report taken from an inmate in Spokane County. The other is a handwritten statement taken by the Latta County Sheriff's Office along with the officer's notes. Additionally, Thomas made a third inculpatory statement after Meister's conviction, which is contained in Meister's motion for a new trial. The first two confessions were made by Thomas to fellow inmates at the Whitman County Jail. The inculpatory statement was made as a threat to a woman who was owed money by Thomas. All three of the statements tend to implicate that Thomas was the person or one of the people responsible for the shooting death of Tanya. The district court ruled in limine that the defense would not be allowed to call Lane Thomas to testify or be allowed to call the persons who heard the confessions potentially to impeach any testimony provided by Lane Thomas. When defense counsel asked for the basis of the court's ruling, the court replied, "I think I've given it." The court did not issue a written order memorializing the basis of its decision. Although the district court applied the wrong standard to determine whether the statements were admissible, the district court did make a finding that the evidence presented in the offer of proof did not sufficiently corroborate the evidence. Therefore, the district court correctly found that some corroboration is necessary in order for the statements to be admissible. The governing standard of whether a third party's statements tending to inculpate the declarant and exculpate the accused is governed by IRE 804(b)(3). Further, this court adopts Arizona's test for a trial court to determine whether the third-party confessions are sufficiently corroborated in accordance with IRE 804(b)(3, that test being, whether evidence in the record corroborating and contradicting the declarant's statement would permit a reasonable person to believe that the statement could be true. This test is desirable because it prevents the trial judge from substituting himself or herself as the ultimate fact finder. If the statements clearly establish trustworthiness through corroborating evidence, it is within the province of the jury to weigh the testimony and determine where the truth lies. The district court applied the wrong standard to determine whether Lane Thomas's confessions should be excluded.
Okay, so that was the entire appellate record for the Meister case. And what it laid out in there was the very complicated rules of evidence around alternate perpetrators. So we're going to go through that. And the first thing, number one, that it has to meet is the evidence must be relevant. And that's Idaho Criminal Rules of Evidence 401. In Idaho law, relevant evidence is defined under Idaho Rule of Evidence 401. Essentially, evidence is considered relevant if it has any tendency to make a fact more or less probable than it would be without the evidence, and if that fact is of consequence in determining the outcome of the action. In simpler terms, relevant evidence is any information that is connected to the case and can help prove or disprove a particular point. So, the evidence must relate to a fact that is important to the case's outcome. The evidence should be helpful in understanding the facts and reaching a conclusion. The evidence doesn't need to be conclusive or definitive, but it must have some bearing on the matter at hand. So examples of relevant evidence are testimony from a witness who directly witnessed an event that is considered relevant, and evidence that affects a witness's honesty, reliability, or ability to recall events is relevant as well. And also relevant are prior convictions. And they may be relevant in some cases, particularly if they relate to the crime being tried. So that is the first hurdle, is the judge must consider the evidence to be relevant. The second hurdle is IRE 403, and that's the controlling authority for the admissibility of alternative perpetrator evidence. And we heard the judge say that he wanted a good explanation of why the defense felt like their evidence in the alternative perpetrator proffer would be admissible. And admissible is the real key to this whole thing, y'all. And the evidence must be admissible, IRE 403. Now look at the caveats, important caveat for whether evidence is admissible or not. Evidence must be admissible. Black Law's Dictionary, 11th edition, defines admissible evidence as A, evidence that is relevant, I mean, we're going back to relevant, and is of such a character, e.g., not unfairly prejudicial based on hearsay or privileged, that the court should receive it. Also termed competent evidence, proper evidence, legal evidence. The character of evidence matters, and depending on the character, it may not be admissible. General requirements for admitting evidence. To be admissible, evidence must be relevant. We keep going back to the relevancy. No formula for determining relevance. No formula for determining relevance. Matter of judicial discretion. This is what's going to get us right here. No formula for determining relevance. Matter of judicial discretion. By furnishing no standards for the determination of relevance, 401 implicitly recognizes that questions of relevance cannot be resolved by mechanical resort to legal formula. Thus, the judge's own experience and conceptions, rather than legal precedents, will often furnish the basis for determinations. It's up to the judge. A district court is accorded a wide discretion in determining the admissibility of evidence under the federal rules of evidence, assessing the probative value, the proffered evidence, and weighing any factors counseling against admissibility is a matter first for the district court's sound judgment under the rules 401 and 403. Create a record. Judge should articulate reasons underlying ruling, and counsel's objection should be short, clear, and state the basis, rule underlying the objection. So when it comes to the rules of admissibility of evidence, number one, they have to meet the rules of relevancy, but two, they also have to be admissible. And the rules of admissibility are there are no rules. It's judge's discretion, basically. But that's where Meister does add one more layer of protection. The appellate court found that in Meister, the third-party evidence consisted of hearsay confessions by Lane Thomas to inmates in the county jail. The appellate court ruled that a test for a trial court to determine whether the third-party confessions are sufficiently corroborated in accordance with Idaho Rules of Evidence 804b3, that test being whether evidence in the record corroborating and contradicting the declarant's statement would permit a reasonable person to believe that the statement could be true. So that is the test for the evidence, is whether it is either corroborating or contradicting the declarant's statement would permit a reasonable person to believe that the statement could be true. So it's got to be something that somebody would believe could be true. If the statements clearly establish trustworthiness through corroborating evidence, it is within the province of the jury to weigh the testimony and determine where the truth lies. So if somebody believes it could be true, that should be admissible, and it should be up to the jury to weigh the testimony to determine where the truth lies. That is the rules of evidence related to the alternative perpetrator, and specifically the test that is included for Meister. But in the end, this is what we have to understand. And I know everybody likes for me to sum everything up and wrap a bow on it. I don't know if I can call this wrapping a bow on this, but once you clearly dive in to how this system works, especially as it relates to the topic we're talking about, the relevancy of the evidence could possibly meet a legal standard And when I say meet a legal standard, I mean the legal standards are broad and wide. Whether something is relevant is largely dictated by the judge's opinion, not necessarily any type of facts, because there's no clear line to relevancy, but there's even less of a clear line to admissibility. Even Black's Law Dictionary spells that out for you. Whether something is admissible is greatly dependent on whether the judge decides it's admissible or not. There is no clear lines. So there is an additional test in Meister that if somebody could believe that something was true, then it should be admissible. But again, it's a broad scope. So in the end, it appears that the way the system is set up, the people that you vote to be a judge or are appointed to be a judge, we should probably pay a lot closer attention to those elections and appointments, because on the district level, the judge and his integrity of the case is greatly going to determine outcomes of rulings on things such as this. And it may be, now, if he was to rule against it and it goes to the appellate court, well, then you've got the appellate judges and how they feel about the admissibility based on, it looks like how they feel, not based on any black or white rules. It looks mostly how they feel. And if they don't get it right, it goes to a higher court and they rule based on how they feel about the admissibility. And then it goes to the Supreme Court, where you've got 12 of them, that rule on how they feel, and the majority of those, get the ruling. But now it makes even more sense why in that motion to continue yesterday, Ann Taylor brought up the alternative perpetrator evidence and how important it was to be able to tell a story at trial. And I can see now that was designed to tug on the judge's heartstrings a little bit about the admissibility of the alternate perpetrator proof that they submitted. So, red pill moment, our legal system, we don't have laws, we have judges. Please like and subscribe to the channel. Post your comments, thoughts, criticisms. Till next time, Pavarotti's out.
until